What kind of discovery are you?
I'm told that about 80% of the information that I'm looking for is in the hands of Wells Fargo, for instance, and the partners in the securitization chain. There's no way an outside individual can get access to that information. And that includes third-party payments, for example. It includes who is the current owner of the note, to whom was the beneficial interest assigned. I know that it's Lehman Brothers in the one case, it is U.S. Bank in another case. There are documents on file at the county. Those I can go and find.
What properties do those documents relate to?
North Bay Springs Road in Cornville, all beneficial interest was transferred to Lehman Brothers Bank on August 14th of 2008. That is right here. And
are there any subsequent assignments from Lehman Brothers to anybody else?
Again, that's...
Well, no, according to you.
The only thing that I've been able to discover through the forensic analysis is that Lehman Brothers bought this along with how many millions of others, and a lot of their properties or their notes were then transferred to Barclays.
Transferred to
Barclays Bank. And the trail appears cold at that point. Obviously, Lehman went into bankruptcy within 30 days of purchasing the note. How do we know? Or how can I discover that?
Normally, I emphasize that word, when one acquires a beneficial interest in a note and mortgage, you record an assignment in the county recorder showing transfer from Wells Fargo to Lehman Brothers to Barclays to whomever.
Correct. And my understanding is that this procedure was not followed. It was frequently simply not done. So we have the transfer from Wells Fargo to Lehman in the one case and the transfer to U.S. Bank in another case, but we don't have any further trail to track down the actual true investors, the people who really actually put up the money.
All right. Let me hear from the other side.
Your Honor, there's only one property that I represent Wells Fargo on.
Which property
This
is
is
that?
2620 North Page Road in Cornville. Everything I heard the debtor just say, I believe, relates to the California property in the 2500 North Page.
Can I ask you a question?
Sure.
Why does Wells Fargo use two law firms in this?
And it's,
You mean Wells Fargo has multiple bankruptcy departments?
yes, in different states.
Okay.
I can tell you the history of.
What's the status of your trustees?
That's what I was going to tell you. The sale was originally set for March 23rd of last year. The debtor, the bankruptcy petition was filed on April 9th. So this sale has been stayed for that period of time. The current date is February 11th.
All right.
And the payment there's been no post-petition payments made.
And you're going to represent to me that Wells Fargo still owns this note?
Yes,
and that.
Yes, Your Honor. When we commence the sale, obviously we get the trustee sale guarantee. I'm not aware of any assignments of this.
And from the bank's perspective on 2620, is there any equity in that property?
No, Your Honor.
Have they done an appraisal on the property?
Probably not since, I don't believe since the bankruptcy's been filed. Probably the one they have, or the last BPO they have, is before our trustee sale was started, which would have been the beginning of 2009.
But they have an appraisal from 2009?
I believe so, Your Honor. I apologize.
And that shows no equity?
That's their belief, Your Honor, based on the principal amount was about $198,000. There's well over, I believe, $25,000 in accrued interest and fees, and when you add all that in, we don't believe that there's any equity left.
Okay. Anything else on your part?
I guess I was just a little confused when you were asking the debtor about when he would be ready for a preliminary hearing and the discovery he said he's seeking. Again, it's my understanding that what he's wanting is on these other loans, because I'm not aware that Wells Fargo has transferred or assigned this loan that's at issue here.
Your understanding is they made the loan and they've held it
Yes.
and owned it from the inception.
And that, we have, declaration from a representative of Wells Fargo that they're the holder and that they're owed this money and they haven't received the payments. As far as the qualified written request, we did submit a timely response to the debtor. Under that statute, under the RESPA statute, A debtor is required to specifically state why he believes that their loan is in error or there's accounting issues. They can't just request a big, laundry list of documents, which is what happened in this case. And frankly, I believe he's done it on all of these properties in question. So we asked him to, we told him we didn't believe it was a proper request and to tell us what he thought was wrong, and we never got a response, and he filed the motion to enforce it here.
Your Honor, I represent Wells on the 2500 North Page Springs. And Your Honor, last October you granted stay relief on that. So, and I think what we're here for today is the debtor's motion for reconsideration on that order. Judge, I haven't heard anything from the debtor or seen anything in his pleadings. Give leave for a reconsideration of that order.
Are you representing to the court that Wells Fargo still owns this note?
They do, Your Honor. Yes.
Have they always owned it, or do they transfer it?
And Your Honor, I'm sorry, I just don't know the answer to that. But again, I know that last October you granted stray relief. The debtor certainly made no payments, approaching 2 years now.
And my memory is from that hearing, but I want you to confirm this if it's correct. And no payments made, which the debtor confirmed since
Correct.
that hearing. Is there any equity in either the Glendale property or the Cornville property?
Your Honor, we don't believe there is.
To your knowledge, is there a trustee sale pending on the 2500 property?
Your Honor, I'm not sure because
Okay.
I know on the California property there is, and he represented that he believes it's today or tomorrow. And my notes are confused as to whether or not there's one for the 2500 North Page.
Okay. Anything else from you, sir?
All I can say is that I believe that my approach has merit. All of the research I've done, so that's opinion, I realize, but I believe that I am in a position with my experts who I have secured.
How quickly can you get me an affidavit from your expert setting forth his explanation as to why Wells Fargo doesn't own the debts that it claims it owns?
Lunchtime? I have it in hand.
Well,
I'm actually
can you have it filed by Friday? Well, what I want you to do by Friday is, so I can read it and understand legally the assertions you're making, is to file your expert's affidavit, and if you want your affidavit showing the court why Wells Fargo no longer owns the debts, promissory notes, and the deeds of trust or lien documentation that relates to the 2520 and the 2500 and the 2620 property in Cornville and the property in Glendale, California.
Right. The properties in Glendale, California and 2500 are, to me, pretty simple because there are documents on file.
All right, well, I want to see whatever you've got. Do you contend that Wells doesn't own the 2620?
This is the unknown one. This was the reason for the request for discovery, because as my understanding is that 90 to 95% of all of these notes were in fact securitized. If they were securitized, then this whole process happened. If it was not and remained in portfolio, I have no contest.
I'll say that again.
If
The last part again.
If Wells Fargo held this property in portfolio, never sold it, never transferred it, never securitized it, then I don't see where I can go.
Okay.
Okay. But I'm doing everything I can to determine whether that's in fact the case. If it is the case, so be it.
Property is until February, so there's a number of weeks between here and there. So you file whatever you want on 2620, 2500, and the Glendale property on Friday. I will look at it. Mr. McDonald, on the court's motion, I don't want any trustee sale, and so I'm ordering that sale stayed on Glendale pending a further ruling by the court, so make sure you get hold of the trustee. I'll look at the stuff on Friday, and then I'll probably do one of two things. To be blunt, if I find it not credible, I'm going to deny the motion for rehearing and probably grant stay relief for Wells on the 2620 property. If it raises sufficient doubt in my mind, 20 property is right, February. So that Wells does not own these notes, then I'll probably set some kind of quick scheduling hearing, be followed by a quick evidentiary hearing to listen to both sides about who owns this debt. And Wells, on both of these motions, is free also by Friday to file their declaration showing that they were, if that's, and are, if that's correct, the owners of the notes and deeds of trust. So I'll take the matter under advisement. I'll look at the materials on Friday, and I'll do my best to get a ruling on the docket sometime next week.
Thank you, Your Honor.
Anything further?
No, Your Honor.